thought we'd start with just an overview of the agenda for today, what we plan to cover. We plan to cover basically from soup to nuts, the process of reporting your invention to us at Tech Ventures and the process by which we understand your invention, make decisions about patenting, the patenting process, and then at the end, we'll go over some best practices on what we can do before we're patenting and as we're going through the patent process to make sure that we're taking a holistic approach to protecting your innovations here at Hopkins. So this here is just a quick slide to give you kind of an overview of what a typical year in tech transfer looks like, to just give a sense of what we're doing from research in the lab, discovery, through filing intellectual property, licensing to either established companies or startups to eventually see a product reach the market from your exciting innovation. So most of what we plan to talk about today is in this part right, starting here, after you discover something, all the way through about here. Certainly I can speak a little bit to license agreements, but really today we're going to focus on the intellectual property process of patenting. And the first part of that process is reporting an invention. And at this point, I'm going to hand it off to Peter so he can walk you through that. He's an expert. He does many of these a week, probably 10 to 20 a month. So I thought he'd be the best one to talk through this with you. And I might chime in, Peter, if that's okay.
Yeah, certainly. Thanks, Jeanine. Would you mind unsharing your screen? I'm sorry, I just have a few animations on mine as we go through the slides, then the next slides, and I can get that going. Okay, and there we go. There we go. So yeah, so thank you, Jeanine, for the introduction to the start of the process by which, we learn of innovators' inventions, and that's these reports of invention that are, really kickstart the process. And these are submitted to JHTV through our Inventor portal, which is available through our website. You log in with your JET ID and you submit a disclosure, a copy of which is sort of shown here. And we've iterated, what is on the form over the years to try to make it as streamlined as possible. We want this to be a pretty fast and easy stage of the process. There's a lot to come after the report of invention, and so we want this part to be easy. There's a limited number of questions, some descriptive, which get at the question of, what is the invention, and that can be as fully detailed as you like. I know Dr. Sewardson likes to put together separate documents that he attaches. Other inventors simply, put a paragraph or two right into the page. But really, the ROI is just to kickstart the process, the conversation with JHTV. And we always make sure that we get all of the information in a conversation afterwards. So don't worry if you feel that you've forgotten something in your ROI or left something out. Another part of the ROI is 7 commercial value questions that sort of get at the question of, what is the problem that's being solved by this invention, and what's the potential impact that this could be. 2 other important things are the funding and the inventor list. Funding is especially important because federal grants come with reporting obligations that JHTV needs to meet in order to fully secure the patent rights if we choose to pursue one. And then the inventor list is important because we need to make sure we get that accurate on a patent filing so that it is it's correct. Inventor lists can be are important so that you don't run into issues down the line. It can be a problem and invalidate a patent. An important piece of these ROIs and just the inventions generally is a question of ownership. So under the IP policy, as a general rule, JHU inventors, such as faculty and staff, are typically required to assign and do assign to JHU. Collaborations with other faculty at other universities or industry partners, most likely those outside collaborators have similar obligations, and the resulting IP would be co-owned between those institutions. That's something we're very used to working with, so don't worry about that at all. Students, on the other hand, are a bit more complicated and may own their own rights depending on what type of student they are and where that work originated. So a general rule of thumb is that undergraduate students, either working on their own, as in their spare time or as part of a class, will own any IP that they develop. But students that are working in a lab under the guidance of a faculty member are typically required to assign their rights to the university. And our IP policy is fully available also at our website, which lays a lot of this out in more detail. So this question of who is an inventor is a little bit different than the calculus for authorship, which I'm sure all of you are very comfortable with. And it's governed by patent law, and patent law breaks down the inventive process into two steps: conception and reduction to practice. So conception is the formation in the mind of the inventor of the definite and permanent idea of the complete invention. So it's a completely mental step and doesn't actually require any physical building of the invention or prototyping. It's really just that spark of an idea in your head, and did you fully think of the invention? Reduction to practice is that step of building the invention. It can be actual in that case, if you actually prototype, build a prototype, for example, or run the tests and really demonstrate the invention. It can also be constructive in the case of simply preparing and filing a patent application, although for JHTV's purposes, we tend to like to see true actual reduction to practice, at least minimally. In practice, of course, these two steps can be intertwined over the course of development of an invention. But importantly, an inventor is someone who contributes to the conception of the invention, but does not need to contribute to reduction to practice. Sole contribution to reduction to practice does not give rise to an inventor. And so where that might come into play in the context of lab research, for example, is if as the faculty member or postdoc directing all of the research and the experiments and how they should be run, and providing instructions to a undergraduate student who's working in the lab to complete the task. The conception of those ideas in the invention may arise from the faculty member and postdoc, whereas the undergraduate may not be an inventor, even though, as I said, they may ultimately appear as an author on a paper. It's important to keep contemporaneous documentation about all of this, particularly in collaborations with outside institutions, so that you can really pinpoint that I, as the inventor, came up with this idea at this stage, and or it was come up with among the group of us at this meeting, and then we brought it to the collaboration with this other institution. And so once you submit that ROI, it comes into JHTV systems, and we have a 222 service commitment to the faculty, as we like to call it. So that first 2 stands for 2 days. And so 2 days, within 2 days of submitting your ROI, JHTV will contact you confirming that we've received your disclosure and letting you know who's been assigned as the intellectual property manager, someone such as myself, or the technology licensing associate, someone like Jeanine, who handles the commercial partnership side of things. Within 2 weeks, the IPM will reach out and hopefully have a meeting to discuss the invention in more detail, but at least try to schedule it. Everyone is, of course, very busy, so we do our best to get it into those first 2 weeks. And that's, as I said, the opportunity to really flesh out JHTV's understanding of the invention so that we can conduct our analysis as fully as possible, and make sure that you've conveyed all of the information that you feel is important to the invention to JHTV. And then over the next few weeks, JHTV will conduct an analysis on the invention that we'll get into in a bit more detail. And after 2 months, we'll provide you with a written decision on your disclosure. And that decision is typically either, yes, we'd like to move forward with a patent, no, we don't want to move forward with a patent, or I find to be the most common response is that, this isn't quite ready for patenting, but we are potentially interested in doing so in the future, perhaps after additional development or perhaps some additional experimental studies to really demonstrate proof of concept of what's.
Say, Peter, a quick question, if I may.
Yep.
On a previous slide, you showed a really high ratio of reports of invention converted to patents issued. That fraction was something like 80%, if I recall, on that previous slide.
Yeah.
It's a bit misleading.
That's a little misleading, and I had a feeling someone might bring that up as I saw that, because that issued patents doesn't stem directly from the ROIs that are received that year. So that 450 issued patents is the result of many, many years of research, and perhaps from ROIs that were disclosed, maybe even up to 10 years ago in some cases. So it's a very long process, and there's no real connection between that 450 disclosure number and the 400 issued patents, at least directly. I mean, of course, that builds up over time. So we want to make sure we have that pipeline.
Is it also that a single ROI can result in many patents issued? Are you counting yeah?
Yes, that is also.
Separately.
Yes, so yes, as we'll get into, you can file many different patents off of a single ROI, either directed to different subject matter or in different jurisdictions, and yes, those would be counted as sort of.
And do you have an idea of what that ratio really is in terms of reports of invention that actually amount in at least one patent issued?
Off the top of my head, I don't have the resulting issued patent ratio, but I know that I think we tend to move forward, at least with that 2-month written decision letter, we move forward, I think, with about a third of the ROIs, at least to the stage of preparing a patent application and filing it. I don't want to comment off the top of my head, what percentage of those end up resulting in issued patents, but roughly 30%, 35% of ROIs that come in will move forward at least to the patent application stage.
Thanks very much. Say, Pete, I think you have an active mic, and it was kind of going in and out during your talk, but I think it's really good if you pretty much shout directly at the screen. I think it was hanging in there.
Okay, sure.
There's also a great question from Kirby. Jeanine, maybe this will come up later, but I'll throw it out there now. Kirby Gong asks, is there a standard for what's deemed ready for patenting? And what's the threshold to demonstrate a proof of concept?
So there's no real sort of firm line that JHTV can say is definite. But I will say that we see ROIs at all sorts of stages of the process, and that's very early stage. We haven't actually built anything. We haven't run any experiments yet, but we have this great idea, and we're going. We applied for a grant, and we're gonna, once we get that money in, we're gonna start building it, and we're gonna start testing it. So it's very easy to say at that stage, great, it looks preliminarily like it might be patentable if things work out the way you think they will, but we really do want to see that you've built that prototype and it's going to function in the way that you think it is, and you have those experiments run to show that it is really functional. Perhaps a good rule of thumb, and this again is just a rule of thumb, and please don't hold me to this, is typically the time of a first manuscript, and we'll get into the timing of publications and how that impacts patenting. But when you're considering what you have enough for a manuscript is generally going to be sufficient for a patent application. and may even be more than what you need for a patent application specifically. But as I'll get into, JHTV likes to be involved in the process much sooner than, once you have that publication, submitted and ready to go. We like to be involved much more earlier in the process so that we can, have that conversation with you about whether we think it's ready or not, what we might need to see, and then get it filed in advance of any potential public disclosures, which can impact the availability of patent rights.
And I guess I would just interject a few things. First, that question was, I think somebody planted it because we were just about to go into some of that on our talk. Great timing, Kirby. Part of, I guess, when I think about timing as far as when to talk to our office, and Peter, you tell me if you think differently, but usually when you're writing up materials and methods and you're putting together the thesis of the experiments that you need to put together for your paper. So close to drafting, maybe you have some proof of, I guess, some additional data you need to gather in order for it to be publication ready. Maybe at that time it's already patent ready, but I will say that usually more data is better than less, and the more we can get in that first filing usually helps with the claims. But as Peter said, it's never too early to talk to us. And then I guess the second piece is what we'll get into on the next slide, is that being patentable is a very important part of our decision-making process, but it's also being marketable and licensable. We have a lot of great impact through publications, and we want to get our research into the world as an institution through publications. And when it makes sense, because patents cost a lot of money, and we'll talk a little bit about it, but it requires your time as well. That we know that's very valuable. We don't want to drain your personal resources looking at patent applications until it's the right thing to do.
Thanks very much.
Okay. Yeah, so moving on, just a little bit, our turnaround rate, we're pretty good about meeting this service commitment to you. And so, yeah, this is the next piece that Jeanine mentioned, and the questions that JHTV asks as we take in a new ROI and a new invention and make the decision as to whether or not to move forward with patenting and commercializing it. And so as the IP manager, my job is to ask the question of, is it patentable, and is it protectable? And I'll get into these requirements in a little bit more detail later on in the talk, but essentially, is it useful? That's a pretty low bar. Is it novel and non-obvious? That's a question about whether your invention already exists or is an obvious extension of what already exists out in the public domain. And that can include, have you yourself already disclosed it? We talked briefly about the, public disclosures and publications, and how that can affect patent rights. I'll get into that in a little more detail. And then this last piece, can it be practiced without undue experimentation? Goes a little bit to Kirby's question of, when is it ready? And if someone who is reading this invention in the patent application, if they would need to conduct a bunch of additional experiments to figure out exactly how to make it work, it's probably not ready to be patented, and the patent office will tell us that and not allow us to get a patent. And an important question we ask in looking at all of that is, what is the scope of the eventual patent? As during my patent attorney time, we would tell clients that, of course, we can get you a patent on anything, and that is true. I think you can generally get a patent on anything. It's just a matter of how narrowly drafted will that patent be around a specific invention. And as a commercial asset, if it's very easy for a competitor to make a slight tweak to the device or a slight tweak to the protocol to get outside of the protection of the patent, but still meet all of the functionality, it's not going to be a very commercially valuable patent. And that's one of the main questions we ask. And so Jeanine has maybe a little bit more to say on the licensing side.
Yeah, and it's okay. You can keep the slides with you to save time. So on the licensing side, when we're making decisions about patenting or contributing to those decisions, mostly on, well, on the decision whether or not to file and on the timing of the filing. Is the research at a stage where there are clear applications that the work being envisioned for patenting is commercially viable? Again, we don't want to I've heard investigators tell me that it takes hours and hours of their time to go through patent applications to make sure they're drafted properly. We want to make sure that we're being mindful of your time and mindful of resources. I think the last time I looked at it costs from the beginning of the filing phase all the way to get a US patent. It's in the range of $30,000 to $50,000 a report. And so we have to be mindful of that. And we have a budget typically of about $8 million a year for patenting. So we have a reasonable budget, but we want to make sure that we're making good decisions with that budget in collaboration with you. And so we look at it if it's commercially valuable and if it's licensable. And for that, you'll recall Peter talked about the 7 questions on the report of invention form. And so we look at those 7 questions with you as we think about the patenting process. Thank you, Peter. So here's those questions kind of in bold in front of you, so you can get a sense of what we're thinking about on the company partnering side as we contribute to this decision of whether or not to move forward or a not yet, which is often the case when we first talk to investigators. So usually there has to be some kind of application that addresses an unmet need. We might look at, honestly, we do look at the market and we look at what it solves, but mostly I think what we're trying to get at there is not so much market size, but really impact. If it's an impactful invention that will make a difference to society, and if patenting this innovation will help get it out into the world. The value proposition, that's a similar kind of thing. Is this a marginal improvement to what's already out there? Potentially kind of thinking about it from Peter's perspective, can it be designed around, or is it something that's really groundbreaking? We would consider patenting both, but that plays into the decision on when we might go ahead with a patent. The customer, who's going to be using this technology, that's something we'll think about. We probably, if we see an unmet need, we'll patent, but we'll need your help answering some of these questions as we decide how to go forward with licensing or partnering with the company. It's always helpful to understand how much funding has been invested to date, who the end user is going to be for the product that you're thinking about, and then what needs to be done in order for it to be commercially viable. That's all things we think about on the market side as we decide with you whether or not we'll move forward with patenting. And I think that's what I wanted to say about the questions.
Okay, so I'll take back over and dig into IP a little bit more, going through the patenting process. So assuming, the ROI has come in, we've done our analysis, we've decided to move forward. What exactly are we actually going for when we say we're filing for a patent? So patent it's a quid pro quo with the public, basically to incentivize inventors to disclose their invention to the public. And what we get when we file a patent, hopefully, if we get an issued patent out of it, is a monopoly on the claimed invention for 20 years. And the public will get a description of that invention in the form of a patent application and issued patent that will allow the public to make and use it freely after that monopoly period is over. And as Jeanine alluded to, sort of the commercialization theory of patents is that, a lot of these inventions require a significant investment to take them from the lab to a commercial product. And so having that patent protection to basically stake the claim that once we are out to market, we're going to be able to have that monopoly and make up that investment in sales is sort of what underlies the idea of patents. So more specifically, patents are exclusionary, which means that as a patent holder, you're granted the right to exclude others from making, using, selling, or importing the invention. You actually don't get a positive right to practice the invention just because you're the patent holder. Doesn't mean you get to go out there and build it, but as the patent holder, it does mean that you can prevent others from doing that. That's enforced through patent litigation. Apple v. Samsung was a pretty famous patent infringement litigation. Pretty recently, Google v. Oracle was another you may have seen in the news. And that's these companies asserting their patent rights and trying to prevent their competitors from making, using, and selling their inventions.
Peter,
Yes.
There was a question, apparently a minute ago, you mentioned something about timing and documentation. And the question, if the patents are now first to file, in what situation could timing come into play or be questioned?
Yeah, so patents have shifted. They used to be first inventor to invent, in which case you could, at the patent office, you could file additional documentation to prove that you had invented the application prior to the filing date of the application. Now, to align the US with how patent rights are administered around the world, we are in a first inventor to file, which means you get a patent application on file. That's when the patent office is going to assume that you have invented it, and they're not going to look before that date anymore. And so that does give us a little bit more impetus to get things filed. We don't want to delay unnecessarily, but at the same time, it's always a balancing act between, is the invention actually ready to be patented? Do we have enough information in the patent application to support it? That again is why we like to start the conversation, early on in the process, so that we can make that decision in conjunction with the inventors. And, researchers are obviously, they know who the competitors are in the field, who's working on similar research. And, if they know that they're working on something very close, that might, push us to move a little bit faster on the patenting process if we really feel that we're in a race to the patent office. So I hope that answers the question. And if not, feel free to follow up afterwards. And so the other point I want to bring up, patents are geographic and only effective in their respective jurisdictions. So that means a patent application filed in the US is going to offer protection in the US only. You can file through mechanisms I'll get into around the world, in Europe, China, Japan, etc. Although that can get very, very costly and is not something JHTV typically does outside of a licensing relationship. Obviously, if a licensee wants to file around the world and wants to pay for it, we're more than happy to do that. But as a general rule, we only file in the United States. So this process of preparing, filing, and examining a patent application through to issuance is called patent prosecution. And so just to give you a sense of how long this process takes, we alluded to this a bit when we talked about the ROIs to the issued patent number. So the process starts with what's called a provisional filing. I've marked that here, time 0. And this is essentially a placeholder application. It's going to be the first thing that we prepare with the inventors. Typically, that process looks like JHTV will engage a law firm to prepare the application. The attorneys will likely want to have a meeting with the inventors, usually half an hour to an hour, to ensure that they fully understand the invention. And then there'll be a series of back and forths where the attorneys prepare an application, look for feedback from the inventors and from JHTV to, again, make sure that they're fully understanding the invention, fully capturing, really what that innovation is and protecting it in the best way possible. And the next step is 12 months after that, we'll convert the provisional application either into a non-provisional application, in which case we file directly in the US, or a PCT filing, which again is a placeholder application that allows us later on to file around the world if we so choose. And this provisional and PCT conversion is perhaps the most important stage of the process. It's really important that inventors are responsive during this time, because this is the last opportunity to update the application, include any new developments that have occurred in the last year, whether that's new embodiments of slight variations of the prototype, or additional supporting data from animal studies perhaps. And again, as Jeanine has said, the more data, the better, the more disclosure, the better. So we want to make sure we get all of that information from inventors in time to really digest it and incorporate it in the best way possible into the PCT filing. And then 30 months after that provisional filing, so we're 2.5 years now into the process, is if we filed a PCT, we then at 30 months file our national stage applications. And this is when we enter into, for example, the US or internationally in Europe, Japan, China, etc. And it's only at that stage are we really submitting the application into each jurisdiction's respective patent offices for patent examination. And that process can take, at least two years, oftentimes much longer than that, and until we finally get patent issuance. And so as you can see, if we have an ROI today and we move forward with a filing after 2 months, and it takes a month or so to get that together, we're still, at least 4 years away from an issued patent, and likely more. And so this stage when we're actually in front of the patent office and they're looking at the patent, that's called patent examination. And that is when patent examiners determine whether the application meets the statutory requirements for patentability. And these are what we look at when we're assessing things at the beginning stages of an ROI. And so there's 4 main ones. So the first one is utility and subject matter eligibility. The statutory code there, these are often referred to by that statutory number at the end, 101, for example. So utility
volume level is right at the threshold of your mic.
Oh, sorry. I'll scooch forward. Thanks, Jeff.
Up and above. Thanks.
So the utility is obviously a pretty easy bar to meet. Is this a useful invention? Subject matter eligibility used to not really be a problem, but in the last decade, we have definitely seen that rear its head and cause some issues with the patenting of software and diagnostics. There's exceptions to what can be patented that include, natural phenomena and abstract ideas, among others. And the courts for a time have said that software, a lot of software, not all software, but a lot of it falls under the exception to patentability of an abstract idea, which does cause some issues and makes us dig in a little bit deeper into software inventions when we see them. But thankfully, in the last couple years, the Patent Office and the courts have made patenting software a bit easier. And internally at JHTV, we've also started moving forward with more of those software patents. The next 2, novelty and non-obviousness, I've alluded to. These, as I said, go into the question of whether your invention is already in the public domain. And if it is in the public domain, there's no, going back to that quid pro quo, there's no need for the government to grant you a monopoly on your invention if the information and invention is already out there. Novelty asks whether your invention exists, full stop, is it already out there? And then again, non-obviousness is a question of whether it's an obvious extension of what's known to one of ordinary skill in the art. This can include your own references, your own manuscripts, your earlier work, and which is why it's very important to come to JHTV before publishing anything on a potential invention. because that publication could be asserted as prior art against a later filed patent application. In the US, we have a 1-year grace period on that, which does give us some leeway in case we do see a prior public disclosure. But a lot of foreign jurisdictions, Europe being the largest, have an absolute novelty bar. So if you've published an application or it's available online prior to filing the patent application, it will very likely prevent obtaining a patent in Europe. And then the last requirement is that that the patent application be drafted in such a way that there's an adequate description of the invention so that one of ordinary skill can make and use the invention. This one, we don't typically, this is a more formalistic sort of patent law requirement that, you know, us at JHTV as the IPMs or the patent attorneys will typically handle on our own. But oftentimes as we go through this process, we will seek inventor feedback on the questions of 102 and 103 and any prior art that the examiners have cited, you know, whether they truly do teach what the examiner is asserting them as teaching, or you know, how they actually can be combined or not into the claimed invention. And so over the course of patent examination, the patent office will issue what's known as an office action, setting out a series of rejections under these different statutory codes. And then the applicant, JHU, will respond with a series of responses, either arguing against the rejections or most often adjusting the claim scope. And that's where we, you know, perhaps narrow the claim scope a bit to get around some of the prior art and really key in on where this invention fits within the prior art. So just, you know, if you take one thing from this presentation, that this is an important one, you really can jeopardize a potential patent with these public disclosures, as I've mentioned. And it's important to know what is a public disclosure. So things like conference presentations, journals, or, you know, online publications, including things like, you know, the archive websites, are considered public disclosures that may impact patentability. Poster sessions, internet posts, blog posts, grant abstracts, when they're awarded, are again publicly searchable and available online. And then theses that are, you know, master's theses, PhD theses that are logged and indexed into the library do become available online. And all of that can be considered a public disclosure. And so it's important to keep those to a minimum prior to we file us filing a patent application. And, you know, there's other mechanisms by which we can protect the process that Jeanine will get into later on in the presentation. So just briefly, a couple of other types of IP that we deal with: copyrights and trademarks. Copyrights are automatic for creative works such as books, images, artwork, and most importantly, software. The software code that's written out is protected by copyright, and that automatically vests. There's no examination process. There's no submission or required submission, I should say, to any government office for that protection to arise. In order for it to be enforced in civil court, though, you do need to register it with the Copyright Office. Again, JHTV typically doesn't do that in the first instance, but certainly can if you know, enforcement is necessary. Trademarks are used to protect brand names. You know, Johns Hopkins University, for example, is a well-known brand and is trademarked. And oftentimes inventors will put a catchy name into their ROIs. Some we've seen, for example, Decide, EpiWatch, OncoSpace. And though this may be useful and to, you know, give it a catchy name to discuss it and create that ease of conversation, it can create confusion with licensee branding down the line, and it does also create confusion inside JHU. And so best practice is essentially to leave that branding and trademarking to the licensee or eventual commercial partner down the line and not worry about that branding.
Okay, great. Well, I'm gonna go over this part quickly. I know we want to leave a lot of time for questions. So this is if when we are successful in licensing your patent, this goes over pretty briefly our policy for distributing. You'll see here that in general, roughly 50% of the distributable income goes back to the inventors in some form, 35% personally, and then 15% back to the lab. So hopefully that's a good incentive to work with us in addition to protecting your inventions. And then maybe Peter, could you forward to the next slide? So we're just putting in here 2 plugs at the end before questions, just thinking about IP protection holistically. It's great to have a patent, but we also have other measures to protect your innovations that are really important. If you plan to talk with a company, either before or after we've put a patent in place, it's always good practice to put CDA or an NDA, non-disclosure agreement, not a new drug application, but a non-disclosure agreement in place so that we can protect ideas that maybe are not patentable. We have a process we can talk to you about if you're interested. And then the next slide, Peter, thank you, is the last thing that we'll talk about today as part of thinking about IP protection. Many of our innovations our tangible materials are also intellectual property. We should be mindful of when we get those in and you use those in your invention, have it papered over in an agreement, and also when you send them out. If you're interested in learning more about MTAs and when to use them, I'd be happy to talk to that as well. And then I think that is the end of our presentation. Mostly just a few, again, best practices at the end to leave you with to submit an ROI in advance. When you want to talk to a company, talk to us and we'll get a confidentiality agreement in place. Mark materials as confidential when you share them. Use MTAs when transferring materials. And I guess first and foremost, please come talk to us when you have questions.
Well, thank you.
Happy to take yours.
Okay, if anyone has questions, you can either put them in chat or you can unmute and ask them directly.
It's the logistical thing. Can we get a copy of these slides?
We'll certainly post the video. I can tell you that. Jeanine and Peter, I imagine you're okay circulating the slides?
Sure, I'll double check with our director. I don't have a problem personally with circulating a PDF of the slides.
Yeah, I don't either.
Great. I think if you've entered your name in full at this meeting, we can circulate that to you. I think that was Kirby, right?
Yep, that was me.
Great. Okay.
And I'll put a chat. I'm going to put in the chat the survey. So if anybody has to leave or at any time before you leave, if you'd take the survey, that would be great. I will post it now, but you're welcome to unmute and ask questions.
Peter, I have a question. I was the one that asked about the first to file.
Mm-hmm.
And if it's first to file, I was wondering, I think you mentioned when you were talking about contemporaneous documentation, that sounded like it was for the inventor to determine when the invention was thought of. When does that become an issue if it's first to file?
Oh, so okay. Oh, yes, I see your question now. I understand now. Yeah. So the contemporaneous documentation I was talking about there and is important for identifying the correct inventor list on a patent application when you do file it. So it's important to know that that you've invented it along with your 2 other colleagues at this particular meeting, and you brought that fully conceived invention to another meeting, and then this 4th person, for example, added, but you already had it, right? You already had it in that previous meeting. And so then you can address, if they ever assert that they are an inventor, you have that documentation to say, no, we actually invented that, before we involved you. So that's a separate issue from that first to file that you've identified. Yeah, thank you.
Jeanine and Peter, I wanted to thank you both. It was great to get both the IP manager and the licensing associate perspectives on this. Peter, you mentioned a bit about patenting of software, and but the question is to both of you, if you could say a little bit more, when is software patentable? When do you feel it's clearly not patentable? Is software associated with a system? You know, is that a different, you know, a bar? Oh darn! And one of our clinical innovators who's developing software just dropped off. It was the question was for her. But can you say a bit more about that?
Yeah. So software has become, thankfully, a little bit more patentable if it is sort of really tied to a specific application, you know, with sort of specific inputs and real world outputs. So what I mean by that is moving things around in the user interface on a screen may not be patentable, but if you're making clinical decisions based on an algorithm that is inputting a bunch of patient data and then spitting out, this patient is at risk for developing this disease, and you should then therefore, you know, practice these clinical steps, that is much more likely to be patentable these days if you have that sort of specificity and, again, real world application.
But I guess I'd interject one thing. If it's just something's patentable, it doesn't mean it makes sense to patent. So what I'm thinking about is that timeline that Peter showed that I thought was really helpful, from when we file to when it issues. And then in thinking about that, whether or not the software is going to still be meaningful and useful 5 years down the line. So if you're filing to protect a software that will be re-engineered in a matter of a year's time, it might not make sense to file, even if it is patentable, because you won't have an issued patent before someone's already designed past you or designed around it. So I think you should think about it from both perspectives.
And in those scenarios where patenting isn't the right step, you know, you still ultimately have copyright protecting the code of that software, and
yeah,
JHTV does work with, you know, licensing software code at times.
Well, that really shines a light on the difference between, say, software and, say, an algorithm, right? A software that might be copyrighted. But I guess what I was really getting at is algorithms. Like, when are algorithms not patentable because they're considered software?
Yeah, so again, the idea or the law behind an abstract idea not being patentable is that the courts didn't want an inventor to basically take a larger slice of the pie than they were entitled to. And so if you have an algorithm and, you know, in your case, for example, Jeff, you're using it for, you know, some CT imaging purpose, some of the, you know, deeper level, more abstracted mathematics behind the algorithm likely wouldn't reach that level of patentability, but using that algorithm to analyze, you know, CT data to then output a better image does put that algorithm, you know, again, into a specific implementation in a, you know, having a real world implication.
Thanks very much. I think that's really important messaging because, you know, over the last couple of years, you know, you hear it repeated, software is not patentable, you know, and I think there was some, you know, there were some changes in law that kind of motivated that, but I think there are some misconceptions out, you know, and I think helping us understand when our computational methods, right, our computational algorithms and stuff are patentable is really helpful. I don't know if Jordan or Kai or others have any thoughts on that. But thank you. What you explained was really helpful. Questions from others?
If someone has an idea for a patent, and for whatever reason, Tech Ventures decides they don't want to patent it, can the inventor then go off and patent it on their own?
That's a good question. So look, so certainly if we don't pursue a patent, we are open to having that conversation about waiving rights in the invention and assigning it back to the investigator. As part of that conversation, we would want to understand whether or not the work is continuing in the laboratory. And the reason for that is that we'd hate to create a situation where we might pass on a foundational invention. Perhaps we feel based on the data that it's not ready for patenting yet, but it's something that you're continuing to develop in your lab. We waive rights and inventions up to the point that we get the disclosure. So only the disclosure is waived. If we assign back and you continue to work on it in your lab, we might create a situation where some rights sit with the inventor, some rights sit with JHU. We decide we want to file on it, and it might be really hard to partner later on when some of the rights sit with the inventor personally, some sit with us, and a company has to manage agreements with two parties in order to partner the invention. So always open to the conversation, but it might not be in the inventor's best interest to do that right away.
Well, that raises a question then, that if there is continuing development that might be patentable and the work is going on and it's not patented early, couldn't early publications invalidate the opportunity to patent later on?
Well, I'll speak a little bit, but I think part of it being patentable is that it has to be enabled. And so if the publication, and I'm probably stepping on Peter's toes here a little bit, but if an invention's not enabled, I don't know that if we filed early that it would be patented, and a publication wouldn't necessarily, it might be some objections that have to be overcome, but I don't know that it would necessarily block a patent if it wasn't enabled at the time of publication. Is that accurate, Peter?
Yeah, I think that's well said. But I will just say, Chuck, that you did identify one of the tensions of working in academic tech transfer, and is that, you know, publications and IP do not always align, and it's trying to find that right balance between understanding that, you know, faculty members do want to publish, they want to publish early and often, and, you know, that we may need a little bit more time to get it into patent application ready form. And, you know, we work with the inventors to explain that in the particular cases where it arises, and, you know, strategize ahead of time so that we can still end up with reasonable patent protection even in the face of earlier publications.
Well, right at 5 o'clock, that's a wonderful summary, I think, to end this on. I think it ties everything together here. So let's thank our speakers. Again, those muted are, I'm sure, yep, are using the chat. So